On December 9, 2018, Lone Rapid Response paramedic Gavin Wood attended a call to an incident where a 17-year-old female was found hanging from a tree. 2 police officers were already on scene providing resuscitation to the patient when Mr. Wood arrived. Shortly after, another paramedic arrived at the scene, and Mr. Wood explained to her that he had already declared patient X deceased on the ground she was in a systole with fixed and dilated pupils. Following complaints from other paramedics on scene and the patient's family, Mr. Wood was investigated for professional misconduct and falsifying documents. Mr. Wood failed to uphold professional standards and adequate patient care, which resulted in acts of professional misconduct. The Health Practitioner Regulation Law Act 2009 defines professional misconduct as unprofessional conduct by the practitioner that is substantially below the standard reasonably expected of a registered health practitioner of an equivalent level of training or experience. In the Queensland Ambulance Service, QAS, professional standards are stipulated by the Australian Health Practitioner Regulation Agency, AHPRA, Paramedicine Board, under Section 38 of the Health Practitioner Regulation National Law. These standards state that a paramedic must perform patient assessment and interventions in accordance with current legislation, AHPRA Shared Code of Conduct, as well as the QAS Code of Conduct and Clinical Practice Manual. QAS clinical practice manuals are informed by the ANZCOR guidelines, which state that unless there are injuries obviously incompatible with life, attempted resuscitation of patients with cardiac arrest due to trauma is not futile and should be attempted. In this case, patient X did not have injuries incompatible with life, and yet Mr. Wood failed to attempt resuscitation as indicated. Reversible causes were also not addressed before CPR, as required by ANZCOR. Consequently, as patient X presented with a vomit-occluded airway, it would be a professional expectation for Mr. Wood to undertake advanced interventions to clear the airways, which he did not. Mr. Wood's clear violation of AHPRA guidelines and the supporting legislation warranted a serious act of professional misconduct. As a paramedic with 21 years of experience, it could be assumed Mr. Wood has encountered similar patient scenarios and has knowledge regarding decreased quality of life and severe functional disability following a hanging. Mr. Wood's decision to cease resuscitation could be justified as a possible utilitarian act that was taken to produce the greatest utility for the patient and their family when considering patient X's long-term outcomes of hypoxic brain injury. While this is a reasonable argument, the AHPRA Code of Conduct states that personal views should not adversely affect the care of the patient. Therefore, Mr. Wood's prior experience alone should not inform his professional practice, further reinforcing the need for resuscitation of patient X in this case. Furthermore, paramedics must uphold the guiding principles of the Health Practitioner Regulation National Law Act 2009, protection of the public and their confidence in the safety of healthcare services. This is further reinforced by a pillar of the Public Sector Ethics Act, which requires practitioners to promote the public good. Patient safety was not upheld by withholding resuscitation, as patient X was not protected from their impending death, regardless of if it was preventable or not. Additionally, as Mr. Wood's colleagues and the parents of patient X directly complained about his actions, it is evident that the public's confidence in Mr. Wood's service was not upheld. Despite his intentions, Mr. Wood's actions ultimately violated what would be expected from a paramedic of his standard, undermining his clinical registration. Mr. Wood was further investigated for falsifying patient records. The requirement of health professionals to maintain accurate and factual clinical records is explicitly stated in a number of laws and codes of conduct. Section 9 of the Public Sector Ethics Act states that public trust requires high standards of public administration, which requires information to be communicated and recorded as openly as practical. Mr. Wood falsified documents when recording that a 30-second ECG that showed a systole was completed, when there was objective evidence that his defibrillator was only operating for 16 seconds, producing artifact, suggesting no ECG was taken. Furthermore, bystanders recalled that no breath or heart sounds were auscultated at any stage during Mr. Wood's care. Consequently, Mr. Wood had insufficient evidence to complete a recognition of life extinct form, suggesting falsification of this record. In the case of McCabe v. Alban District Hospital, the judge ruled that the hospital staff were liable for the death of their patient due to failing to adequately document their interventions and patient deterioration. Consequently, under the authority of Queensland legislation, AHPRA codes of conduct and previous court rulings, Mr. Wood could be found liable for falsifying documents. In spite of this, it is plausible that Mr. Wood experienced fatigue at the end of his night shift, resulting from the consequence of shift work and a paramedic's workload. This can cause adverse consequences for patients. While this is reasonable, AHPRA guidelines clearly state that fatigue should be considered and managed when assessing one's fitness to practice. It is assumed that Mr. Wood's action of falsifying records was done so to avoid negative consequences from professional misconduct allegations. This can be understood through ethical egoism, which involves doing what is best for oneself regardless of outcomes for others. As an experienced paramedic, Mr. Wood is justified in wanting to maintain his employment and continue providing care to patients. And retrospectively, it would have become clear that falsifying the patient record was required to do so. Ethical egoism can be refuted by the coroner's court inquest into the death of Zamir Eli Smith. The act of providing false readings to hide a perceived failure and to take appropriate action was criticised by the New South Wales coroner, as it ultimately resulted in insufficient action being taken by practitioners to save Miss Eli Smith, as her condition was misinformed by the false paperwork. This highlights how Mr. Wood's ethical egoism contributed to patient X's death, as other paramedics on scene were unable to correct this misconduct due to being misguided about the patient's condition. This is further supported by the AHPRA Shared Code of Conduct when it recognises that the falsification of medical records poses risk to patients, as records can inform future decisions and may be relied upon by other practitioners. Furthermore, deontology emphasises the importance of acting according to one's duty and following universal rules. Widespread falsification of patient records would be detrimental to patient safety and undermines the trust that the public places in paramedics, thus compromising the integrity of the profession. Mr. Wood failed in this instance and ultimately cannot be justified for his actions. It is evident that Mr. Wood was guilty of professional misconduct due to his failings to meet professional standards of practice and accurately document his interventions. In the interest of patient safety, it is essential that Mr. Wood receives disciplinary action. Failings of this nature can often be addressed by a period of good behaviour or supervised practice. However, the success of this would be dependent on Mr. Wood's willingness to learn from his mistakes and change his behaviours. Mr. Wood did not attend his trial, which indicates a strong unwillingness to acknowledge his errors. It is likely that a suspension or dismissal would be the required disciplinary action for Mr. Wood to prevent a repeat event of this nature and ensure future patient safety.